Mr. Chair, we are in public session.
Very much. All right, good morning, everyone. I'm calling the meeting to order pursuant to Executive Law 94-4, public session. I believe we have all members of the commission present, except Commissioner Hendricks. Contacted me in advance and advised me that he would not be able to attend today. Moving on with the agenda, the approval of the February 15, 2022 minutes. Commissioners have not already reviewed them. Please take a moment to review them, and I need a motion to approve.
So moved.
So moved by Commissioner Braun, seconded by Commissioner Weissman. All in favor, please raise your hand.
Aye. Aye.
I'm having difficulty
Can you see?
seeing individuals' cameras, so I just want to make sure that we're taking a roll call on this.
Chair, we see all hands except Commissioner DePiero, who has no video.
And Commissioner DePiero, are you approving?
Yes, I approve.
Okay. It's unanimous.
Okay, unanimous vote. Moving on to the agenda, there's a report from staff on operations. Who's presenting?
I am. Good morning, all. The operations update is under tab B, attachment B. Staff is happy to answer any questions commissioners may have with respect to operations during the preceding months and year to date. I will add that we expect going forward, and it'll be reflected in next month's report, an uptick in lobbying inquiries and FDS filings as a result of the web applications having been down for approximately 3 weeks during the reporting period and lapping into the current month. Any questions?
Are there any questions from the commissioners? Commissioner Braun?
As I've raised in the past, under training, numbers of individuals overdue for ethics training now as of February 9th, 2022. It says year-to-date 1,774, meaning 1,774 individuals who are overdue for their ethics training. And then it says in notes 85 more than prior month. Why is it slipping backwards, and why is it so many?
So Judge Braun, the training numbers, as you know, reflect a rolling requirement of individuals who have individual due dates based on their time in service and when they joined and when they last trained. Because this is the start of a 3-year cycle and training is due every 3 years, we would expect to see those numbers actually increase this year before they go back down. People are coming due. Yes, there are some that are delinquent already, but this is not surprising at the moment, and we'll monitor it as the year goes on, but we are going to have a massive influx of people who are due for training this year. But we do engage in compliance with the agencies and try to work to bring everybody up to speed on that. But this is the start of a new training cycle.
Well, it's our overseeing responsibility, but it's the agency's responsibility also to make sure their employees get proper ethics trainings. Why are there so many individuals that the agencies are not pushing harder to get their ethics training, to make sure they're acting ethically in their job positions as state employees on behalf of the voters and constituents of the state of New York?
This is Keith St. John. If I might add, because of the 3-week downtime that the system suffered, another reason for the unusual, well, in some respect, as Martin said, an uptick in those numbers but it was only exacerbated because of the 3-week down period, which did not allow for agency ethics officers to actually input data regarding trainings that might have been going on, but not yet reported to us. So we expect the increase in numbers is not a big surprise, but equally concerning, but not necessarily alarming because of the 3-week period in which agencies could not update their figures.
Let me just add, aside, your beard has gotten even nicer, Keith.
Thank you.
And Commissioner, Judge Braun, I'll just point out that one of the things the Commission has recommended in the past is that the legislature consider adding penalties for failure to take training, but that remains not part of the statute.
Thank you.
All right, no further questions from the commissioners? Great. Moving on to the regulations and guidelines section, I believe there's a resolution we have to pass. Who's presenting on that?
I will,
Chair
Nieves. The adjudicatory proceedings and appeals process regulations were adopted on an emergency basis at the February meeting. That emergency adoption is slated to expire, unfortunately, the day before our April meeting. And so in order to avoid any sort of gap, we're asking for your vote today to re-adopt those on another emergency basis. There are no substantive changes. The permanent rulemaking remains open with comments accepted until April 10. This is simply a procedural mechanism to ensure that those regs don't expire between meetings. So we'll have a substantive presentation next month on any comments we receive or any changes we recommend. But right now, like I said, this is just a procedural vote to ensure there isn't a gap.
Any questions from the commissioners?
All right, so we do need a motion to
Commissioner
re-adopt.
Fisher, I move that we pass the resolution for the emergency readoption as described.
Second.
Weitzman, second.
Second.
Thank you.
Okay, Weiss, Judge. Commissioner Weiss.
Aye.
I think we moved on to the vote.
Yes. All in favor?
Yep, I see.
Aye.
I think it's
I
unanimous.
see
I
all
can't
hands,
see.
unless Commissioner Levine, I haven't seen you yet. There it is.
It's unanimous. All right,
Any
thank you.
opposed? Opposed? Any abstentions? No abstentions, it's unanimous.
Thank you.
Thank you. Let me just add before we go, Chair, before we go into the next item, the Confidentiality Committee did meet last week to discuss Commissioner Fisher's proposed amendment to the Commissioner Code of Conduct. Commissioner Fisher has withdrawn that motion in order to consider the issues in the context of the rulemaking. So we will re-examine those issues at the next commission meeting when we go on to the formal rulemaking.
All right, thank you. Moving on to new and other business. Any commissioner has new and other business? Commissioner Levine?
Can you hear me, Mr. Chairman?
I hear you, Commissioner Levine. Go
Thank
ahead.
you very much, Mr. Chairman. To advance the objective of maximizing openness in our deliberation, I move that the Commission's Code of Conduct be amended to require that with respect to any recusal or abstention, Commissioner must state on the record the reason for the recusal or the abstention. Thank you, Mr. Chairman.
Is there a second on that motion?
See Commissioner Jacob.
Commissioner Jacob?
I second it.
Okay, Commissioner Jacob has favor, please raise your hand.
Before we go to a vote, could I ask a question?
Go ahead, Commissioner Fish.
And this is new to me, maybe it was in our materials and I missed it, but if not, what is the current policy and what is the, I guess, rationale for this, Commissioner Levine?
I could answer, if I may, Chair, on the first part of Commissioner Fisher's question. The Commission's formal recusal policy and procedure at Section 4 provides for procedure for recusal in accordance with the Commission's guidelines, and essentially commissioners are called upon, to the extent they can make the determination before an issue comes up at a meeting, to so inform the chair of their intention to recuse.
So if we so inform the chair in advance of the meeting, would that suffice, or would we still need to state or restate the reason for the refusal at the meeting, even if we had informed the chair ahead of time?
The object, Commissioner Fisher, is to maximize openness on our trajectory exiting the star chain. It can be said fairly, I believe, that it is antithetical to openness to conduct a vote and have a commissioner abstain or recuse without explaining the abstention of the recusal.
Further questions?
Chair, if I could just add one other thing with respect to the current recusal policy. There is a procedure in the policy that parallels subsection 16 of Section 94 of the Executive Law in affording commissioners the opportunity to confer with staff with respect to whether or not recusal is called for, whatever the factual circumstances may be. And just as under subsection 16, that consultation, that guidance, that advice is confidential. The same treatment is afforded to a commissioner's inquiry about recusal. So the Commission's own policies do recognize that there may be interests that are protected and should be protected in seeking guidance and with respect to the reasons for recusal. So I'm simply clarifying what the existing policy and practice is and has been since those recusal policies were adopted by the Commission.
Are there any other questions? Okay, hearing no questions.
Wait, two hands up.
Where, please?
Excuse me, Mr. Chair. I had my hand up and Commissioner Jacob had.
Okay, I don't have a visual. Okay, I don't have a visual. For some reason, your videos are not appearing on my screen. So I would just ask that you verbalize any question or any intent to make a statement.
Shall I go
Commissioner?
Okay. As you commissioners know, a few times, and a very few times, have I made disclosures about certain things before to the commission and recused myself, maybe a handful of times. As a judge, as a former judge, the rules of judicial ethics did not require us to state a reason for recusal, but I almost always did for reasons of what Commissioner Levine is now speaking of, which is openness and transparency, and actually went way beyond what I had to in making disclosures. For example, I went to NYU, started college, and I had a few cases with NYU as a defendant. I still disclose that, though it's been maybe a couple of years since I went to college there. And lawyers actually thanked me for making disclosures I did. But let me raise a question to you, Commissioner Levine. There might very well be certain circumstances occasionally where a commissioner feels very uncomfortable to publicly disclose something where he or she is recusing due to certain personal reasons. It doesn't sound as if there's anything contained in your resolution that would allow for such a circumstance. So you're saying there should be full and complete openness and transparency always, or is there any, could there be any allowance for something that's really so personal to a commissioner that he or she didn't want to publicly disclose the reason for recusal?
You've raised a significant point, Judge. Let me clarify that the motion is not intended to obviate any of the usual privileges or confidentiality considerations. As an exemplar, if a lawyer who is serving as a commissioner recuses because of a client relationship, it would suffice to say, I'm recusing because there's a client relationship. But privilege, with the lawyer-client privilege that the attorney is subject to, would still obtain. There would not be a need to disclose any further information to the other commissioners.
The same for medical reasons.
Yes, all the usual privileges.
So could you amend your resolution to include such a provision so it'll be clear to everybody?
Yes, thank you.
I'm certainly, as I've said a number of times before, I think it's very important for government, and in this case, our commission, to be open and transparent. And therefore, I support your resolution as long as there is such a provision included in your resolution.
Thank you, Judge. Mr. Chairman, I amend the proposal to accommodate all the usual privileges and other confidentiality protocols provided by law.
Any other questions?
May I be heard?
Okay, I can't see you, so.
Anthony, let me see if I can fix that. I don't know why you...
Commissioner Jacob?
Yes, I'm trying to...
No, go ahead.
We can see you, Mark, but I think
We
it's
can see
online.
you. Commissioner
see me?
Braun, I can see you,
Okay.
Marvin.
The reason I am in favor of this motion is because of what happened at our last meeting, which, for me, having been on here since inception, was the first time such a thing had happened. We had 5 abstentions on a particular vote. We began with less, and on the second go-around, persons who voted against switched their vote to abstain, and a person who voted for switched his or her vote to abstain. So we had abstentions coming from all directions, some that were taken on the initial vote, others that were switches, but we ended up on a 12-person commission, narrowly missing passage because we got 7 votes and 5 abstentions. Now, unfortunately, and I will make this motion afterwards, there is nothing in our guidelines on when a member may abstain or should abstain. There is for recusal. There's a long list of items on recusal. On abstention, it's just wide open. There's nothing there to guide members as to when abstention is appropriate. And frankly, I don't even know. But after the last instance, when we had a 7-5 vote, and all 5s were not no's. They were in effect no's because some was switching. One was a switch from a yes to an abstention, another was from a no to an abstention, and then there were 3 abstentions. I'm sympathetic to the notion. I feel that we ought to know when abstention is appropriate, but going past that, because that's not part of this motion, if there's going to be abstentions that are the equivalent of no's that defeat motions, we ought to have the kind of disclosure that Commissioner Levine and Commissioner Braun is talking about. That's why I support the motion. Thank you.
Any other comments or questions?
Mr. Chair?
and that's Commissioner
Person.
Kurtzman. Go ahead.
I agree entirely with Commissioner Jacob. And in fact, I was fully prepared. I was one of the persons who abstained on both of those motions at the last meeting. And I was fully prepared to explain my abstentions at that time. And, I'll put on the record, it's very, very difficult for us that are fairly new to this commission to vote on matters of situations that occurred long before we joined the commission. And under those circumstances, I thought it was most appropriate for me to abstain. But I'm perfectly happy at all times to not only put those the reasons for abstention or recusal on the record, but I also agree that maybe some guidelines as to when it is appropriate to abstain might be in order.
May I be heard, Mr. Chair?
Go ahead, Commissioner
I
Brown.
agree with Commissioner Gerstmann. I was one who switched from a no to an abstain, and the reason I abstained is because it was asking for a vote on a situation that occurred way before I was a board member, and I didn't feel like there was enough information to make that determination. I also agree with Commissioner Jacob that more information or guidance should be given as to when someone should abstain versus just outright voting no. And so I think the motion that's made is a little premature until that guidance is given. I can support the motion if it is pertaining to the recusal and all of the confidentiality issues that obtain to that. But the piece regarding, whether or not it's appropriate or wanting you to explain why you are abstaining when there is a lack of guidance given about when that is appropriate, I think should be resolved first.
He's not going to see you.
Mr. Chairman? Yeah, may I make a suggestion on behalf of staff that we undertake to draft guidelines for the commissioners to consider with respect to both recusals, to supplement what's already in the recusal policy, and more specifically with respect to disclosures as to abstentions. And maybe that would be useful and help focus the discussion. We haven't had an opportunity to consider this previously, and it might be helpful to everyone if we could have the opportunity to do that.
That's fine. I think that's a great idea. Commissioner Levine, would you withdraw your motion at this time to represent it at the next meeting? Hopefully we have that guidance.
Yes, Mr. Chairman.
All right, thank you.
All right, we'll have that ready for the next meeting.
Are there any other, I appreciate that.
Yes, Mr. Chairman, thank you very much. I am going to renew the motion made at the special meeting to importune Inspector General Lane to reopen the investigation of the breach of confidentiality that occurred at our meeting in January of 2019. A breach which I view as a fundamental subversion of ethics administration in the state. Time constraint in the last discussion precluded me from presenting the rationale for the motion. If I may, Mr. Chairman, not once but twice,
Go ahead, Commissioner.
the Commission has made a criminal referral to the Attorney General with respect to the same incident. Of course, as has been stated previously, and I want to reiterate for emphasis, the Attorney General, in conducting a criminal investigation, is subject to a burden of proof which is the highest of standard, beyond a reasonable doubt. The Inspector General, in conducting an inquiry which is not criminal, is not subject to a standard of proof beyond a reasonable doubt. In any event, it is my view that the integrity of the operation of the Office of Inspector General requires that the matter be reopened and that the Inspector General be given another opportunity to bring to ground exactly what transpired in the breach of confidentiality that occurred in communication with former Governor Cuomo. I therefore move that the Commission direct the Executive Director to communicate to the Inspector General that the Commission requests a reopening of the investigation of the leak of the meeting of January 2019.
And just to be clear, this is the same motion that was presented during the special meeting?
That is correct. By the way, I want to make one other point, if I may, Mr. Chair, and I appreciate your indulgence. 3 years may have expired since the incident. There's no question there was a leak. However, other attorneys on the Commission may correct me if I'm wrong, but the statute of limitations is told for those continuing to hold public office. Therefore, arguably, if the leaker is still holding public office, the statute of limitations on a criminal referral from the Inspector General is not told. In any event, it also needs to be clarified, contrary to statements that have been made by the prior administration, the law creating the Office of Inspector General required the recipient of the information that resulted from a breach of confidentiality to notify the Inspector General. And so far as we can ascertain, this did not occur either and ought to be included within the ambit of the investigation. That's reopened. Thank you very much, Mr. Chairman.
Thank you, Commissioner Vaughn. I just have a question. On this motion, has it been presented to the Commission on prior date?
2-year statute.
This, this motion, yes, was presented at the last meeting. There have been certainly a number of votes on this issue going back over the last 3 years, I think 7 or 8 of those. But this particular motion was presented at the last meeting.
Okay. All right. Any other questions? No, I see no further questions or comments. All in favor, please raise your hand.
We need a second, Mr. Chairman.
And I need a roll call. I need a roll call on this.
It's a 2-year
It
misdemeanor.
looks like Weissman on a second. Am I correct, Commissioner?
Yeah, so we can move on.
Okay.
Mr. Chair, may I make one observation? Just for clarification.
Go ahead.
At least under our statute, a referral under subsection 9-A for a disclosure of confidential information of the Commission, and an authorized disclosure, is deemed to be a misdemeanor, which would be governed by a higher burden of proof beyond a reasonable doubt. It is a criminal charge. And I believe, but we haven't had an opportunity to research this, that a 2-year statute of limitations does apply.
Pardon me, Mr. Chairman. I have had an opportunity to research the matter, and I believe the Executive Director is in error with his pronouncement. The Inspector General has, under its Enabling Act, no prosecutorial power. It has an investigatory function, and it may make a referral for a criminal inquiry. It is the case, as Judge Berland has indicated, that the leak itself is a misdemeanor. but the extrapolation to the proposition that the Inspector General would prosecute a criminal case is in error.
Just to be clear, I'm not suggesting that the Inspector General would be prosecuting a criminal case. I was simply clarifying that under our statute, under Section 94 of the Executive Law, an unauthorized disclosure of confidential commission information is deemed to be a misdemeanor and is referred for investigation. I didn't say prosecution, for investigation to the Inspector General. And it was my understanding, which may well have been an error, and hence I would like clarification on this. It was my understanding that that was the referral you were seeking, to investigate a potential misdemeanor.
Mr. Chairman, I repeat for emphasis. The Inspector General has no prosecutorial power under the Enabling Act. Any inquiry conducted by the Inspector General, which may result in a referral, is nonetheless not subject to the burden of proof beyond a reasonable doubt.
Mr. Chair?
Go ahead, Commissioner Joe Gerson.
As I understand it, this matter was at least once before, referred to the Attorney General and the Inspector General, and the Inspector General did issue a report of some sort. I will say, as someone who was not a commissioner at the time of either the incident or the time of the report, I have never seen that report, nor do I understand what may have been deficient with respect to that report. And for those reasons, I cannot vote, and I will continue to abstain.
Mr. Chairman, if I may, with respect to the report, it was approximately a 3-page letter by the then Executive Deputy Inspector General Spencer Friedman. The letter stated that no leak could be determined to have occurred. It was obviously a sham when it was issued, and subsequent acknowledgement by the Speaker that the Governor confronted the Speaker with the actual vote of the Speaker's appointees that day, and the confrontation occurred the same afternoon, put to the lie the proposition that no leak occurred. Subsequent to the Speaker's acknowledgement, the then Executive Deputy Inspector General refused to reopen the inquiry and stood by the conclusion. Again, it was a sham right from the beginning.
Mr. Chair?
Are we ready to take a vote?
Can I speak, Mr. Chair?
Hey, Commissioner Braun. Go ahead, Commissioner Braun.
I also was not on the commission at the time of this leak that we've heard about occurred. I've never seen the reports or the letter, as Commissioner Levine put it. It's been my understanding that 2 critical people were not interviewed by the Inspector General, but I have no knowledge of that. It's purely hearsay. So I'd like somebody, including you, Commissioner Levine, possibly to speak to that.
Yes, thank you, Judge Braun. First of all, I want to address this proposition that commissioners that were not present contemporaneously with the events. I cannot agree with that assertion. I believe we all have a responsibility, whether we were there contemporaneously or not, to address the current issues. I strongly emphasize that the Commission has not once but twice already referred this matter to the Attorney General. It would be highly anomalous not to request the Inspector General to reopen the same matter that we have made a criminal referral to the Attorney General. With respect to the the deficiencies in the inquiry. Commissioner Yates and Commissioner Garcia did their duty. They became aware that a leak likely occurred. The then Executive Director, Seth Agata, was informed. Mr. Agata informed the Office of Inspector General. The then Inspector General recused herself because she had been our Executive Director, and Mr. Friedman took over the inquiry. So far as anyone can ascertain, and I don't believe the Office of Inspector General has denied, the governor was never interviewed. He was never asked the question, who gave you this information? The speaker was never interviewed. So for Mr. Friedman to conclude that a leak could not be determined to have happened without interviewing the recipient of the information puts an exclamation point to the proposition that the whole exercise was a sham.
Mr. Chair,
Go ahead, Commissioner
may
Weissman.
I ask, I second the motion. May I ask Commissioner Levine to withdraw the motion until next meeting, permit staff to provide to Commissioner Brown, Commissioner Gertzman, Commissioner Braun, and whoever else has not received, who did not live this with us, whatever information is available, including the Inspector General's report, so they have so the new, what I'm going to call the newer commissioners, have the opportunity to review it, and then they can make their decision based on what's before them.
Mr. Chairman, I will agree with the suggestion of Commissioner Weissman so that the commissioners can be fully informed. I would also request in parallel that you make a follow-on communication with the Office of Attorney General to find out whether they've ever initiated its criminal investigation. But I agree to the suggestion proffered by Commissioner Weiss.
And let me add, thank you, Commissioner Weissman. Could you also add any information there is that the governor and the speaker and anybody else pertinent were never interviewed, rather than just supposition, possible analysis of the circumstances, and coming to the conclusion they weren't? If there's any information we have, I would like to hear about that.
May I just make one comment?
Go ahead, Commissioner.
There was extensive testimony by former Commissioner Garcia, who was a recipient of information. She testified in the New York State Senate for an extensive amount of time. The legislators were apparently very interested as to what happened that caused her to so abruptly resign from this commission upon receipt of the report of the Inspector General, which report stated that the leak could not be substantiated. Given her knowledge, she could not tolerate that, apparently. She could not understand it, and she abruptly resigned from this commission when the IG, the Inspector General, sent us that report. But I would ask that to get a full understanding of what actually happened, staff may wish to get a copy of that transcript in the New York State Senate hearing at which former Commissioner Garcia testified, and that would fill in all the holes, it seems to me, which are being probed at the moment.
All right, Staff Executive Director Berlin, I'm going to direct staff to respond to Commissioner's inquiries for further information. Please see me on the information that's provided so I can review it myself, but make sure that the information is given freely to any commissioner who's seeking it.
We will do that. Thank you.
All right. Motion being, I would ask for a motion to move into session.
Mr. Chairman,
Executive Law 94.
Mr. Chairman,
Go ahead.
if I may,
Meeting schedule.
it's a question, not a motion. The predicate of the question is that the governor and the legislature are in a discussion, if not a negotiation, with respect to fundamental ethics reform, at least reform of ethics administration. Do you anticipate the commission institutionally opining with respect to what proposals should be adopted?
I believe that might be an issue we will discuss in executive session under new and other business as to what, if any, opportunities the agency will have to, have input in the process. I will discuss that in executive session. Thank you.
Chair, there's one other item.
Motion to move it.
One other item
Go
before
ahead.
we go into executive session. Under tab D, maybe apropos of Commissioner Levine's observation, we have the proposed meeting schedule for the second half of the year. It's behind tab D. Not asking for a vote at this time, but if any commissioners have any concerns or questions about the schedule, please let us know so we can make appropriate adjustments before the schedule is formally adopted.
The schedule will be formally adopted at the next meeting, correct?
We don't need a vote, we'll finalize it. Please let us know if you have conflicts before the next meeting.
Okay, very good.
All right. Thank you.
So by the next meeting, the schedule should be fine. All right, can I have a motion to move into executive session?
So moved.
Seconded.
By Commissioner
Brown.
and I'm sorry, Commissioner Brown, and second by Commissioner Fisher. All in favor? Is it unanimous?
Yes.
Okay. Unanimous vote, we'll move into executive session. Thank you. Yeah, Morton?
Yeah.
Further steps, I would say further steps with respect to a prior resolution.
Yeah. Okay. I can go ahead, Chair, if you're ready. So in executive session, the Commission...
Go ahead.
In executive session, the Commission discussed matters related to litigation and legal advice. Commission commenced one substantial basis investigation, closed one substantial basis investigation, authorized steps in several investigations, authorized certain steps in an inquiry, and authorized further steps in with regard to a prior resolution.
All right, thank you.
I think that's it.
Unless there's anything further, Mr. Chair, we can take a motion to adjourn.
Ask for a motion to adjourn the meeting.
So moved.
So moved by Commissioner.
All in favor?
Aye.
Yep.
Aye.
It's unanimous.
All in favor, say aye.
Aye.
All right, good afternoon, everyone.
Everyone be well.
All right.